As we wait for the jury, I thought it might be nice to perhaps take a retrospective look at some of the sentinel moments in this trial. And with that in mind, that's what I'm going to do. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. In this trial, there were numerous examples of witnesses who were caught lying. There were alleged experts who turned out not to be such great experts. There were just some moments in this trial that made my mouth drop, what? And I don't I don't normally have that experience with trials. Normally the evidence comes in pretty much the way you expect it to. The cross-examination goes pretty much the way you expect it to, but not in this case. And in fact, notably different than probably 90% of cases out there. This was a battle royal between a great lawyer and a good lawyer. And by good, I mean technically good, not necessarily morally good. So, in no particular order, I'm going to go through some of the witnesses that the state put on, some that the defense put on, and just kind of remind you of all of the things that have gone on, some of the things that I've talked about in this trial, and perhaps you'll find it interesting as a retrospective of this trial. This is going to be a much longer video than most are, but again, if you haven't watched the whole trial, you haven't seen all my videos on this trial, it's a good way to familiarize yourself with at least some of the more relevant facts in this case. So the first thing I want to look at is Mr. Alessi's cross-examination of Ms. Hyde, who was one of the state's cell phone experts.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable.
What's notable about this is the way in which the judge limits the cross-examination. That's the first part.
In March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object. You have to move along from this case, from what you're talking about. You have to move around.
I do.
And is it correct that in that case, you submitted arguments on behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but the friends of the court, you took a position in that, quote, friends of the court brief, correct?
Took a position on the evidence.
Right, and the position you took on the evidence was that the frequent location history data is reliable and should be used. Is that correct? I'll repeat, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. You see that statement?
Yes.
And that if you skip down, I'm going to skip a couple sentences to the paragraph under the chart, and this is the key part.
Okay.
It says, from that point, and I'm understanding that point to be the 12:20:50 a.m., correct?
Mm-hmm.
You need to say yes or no, I'm sorry.
Yes.
There is no indication of interaction with the device. Did I read that correctly?
That is correct.
So I am going to And you believe that statement is correct?
Until 6 something a.m.
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct?
I object.
Can you answer that? Can you answer that, yes or no?
Did I read that correctly?
You read it correctly.
Thank
yes.
you. If we could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39. And it will be, thank you. And if we could go to slide 82, please. And Ms. Hyde, if I could draw your attention to the entry that is, it says 3209 under app lock, but we know that the 00 is a 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red, and this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us, he said device locked with lock button for the last time. Do you see that?
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. Do you know that?
Yes, sir.
Okay. And that is an interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be accurate as a digital forensic analyzer on the topic of the last of an indication of interaction with the device? Don't you think it would have been appropriate to look at that 12:32:09 in any of the tools you said you used on direct?
I did not correlate that artifact in my timeline.
I understand you didn't, and my question is, you make a statement. Well, let me back up. Do you understand that in this case, as in many cases, that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report, that from that point, 12/20/50, there is no indication of interaction with the device, is incorrect?
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
And then the second part goes down to what a sloppy job she did in evaluating this phone. Like almost all the experts hired by the Commonwealth, they just couldn't get somebody to do their job or do it the right way. But when the prosecution wanted to be over the top and go ugly on the witnesses, particularly Dr. Wolf, who in a voir dire, which occurs outside the presence of a jury, he was mean and nasty. And the reason he was mean and nasty here and not so much in the trial is because he didn't want to create a bad impression for the jurors. But what you see here is Mr. Brennan's real personality. Let's watch.
Well, when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness.
No.
Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So are you finished with your answer, Dr. Wolf, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So as I mentioned, again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
So what you saw there with that "you're not answering my question" thing is actually the man was answering the question. If he had asked it differently, if he had used a leading question, he could have gotten the answer that he wanted to. But what he wanted to create was this idea that the expert's being obstreperous. And it might have worked with the jury if he had done that, but it didn't work with the judge. I think she saw through it. At the end of this, she allowed Arca to testify, and one of the few good rulings that she made in the course of this trial. Most of them were not nearly as good. Next, we're going to take a look at the cell phone expert who talked about how the battery revealed the ambient temperature. And this is one of the things that they worked into the defense quite well, and I think may, at the end of the day, be sort of a saving grace for Karen Reed.
Record ambient or the environmental temperature where the phone may be at any given time, correct?
Correct.
But the iPhones, including the iPhone of John O'Keefe, log the temperature of the battery inside of it, correct?
Correct.
And as a result of that function, examiners and folks like you can use the battery temperature of an iPhone to identify increases or decreases in temperature within the environment that the iPhone is physically located in. True?
I believe so, yes.
And that's right out of your report, right? Your March 2025 report makes that very statement, correct?
Yes.
The battery temperature of an iPhone generally matches the pattern of the rise and the fall of the thermometer temperature, correct?
From my testing, yes.
And when an iPhone is in a lock state with little activity occurring on the device, the battery temperature is heavily affected by the ambient temperature in the environment, again, matching the pattern of the rise and the fall of the thermometer temperature, right?
Correct.
And what I just read is right out of your March 2025 report, correct?
It sounds like it is.
To take the final step to see whether there was anything to be gained from that comparison to determine where that phone was located?
My testing proved that the battery temperature is affected by ambient temperature. My report shows the data that was on the device. I also don't know the condition that the phone was found in, whether it was in a case, whether it was in a pocket. So to me, the ambient temperature in Canton at the time wasn't particularly relevant.
Now let's take a look at the expert by the name of Mr. Burgess. I'm not going to focus here on the rather stunning testimony where he admitted outright that he basically lied about having a bachelor's degree. I'm going to take you to the point that probably really matters more than anything else, which is his methodology and his work product. Let's watch.
I want to cover a basic question. Do you have any citation to any scientific literature where specifically what you did on this Lexus model has ever done before? Has it ever been done before?
No, not on this specific model, which is why we did the exemplar testing.
Right. So there's no scientific literature that states that the methodology that you used with this Lexus model is an appropriate methodology at all, correct?
There is literature that addresses the methodology in other ways, but not specific to this Lexis, correct?
There's no literature at all stating that the methodology that you used for this Lexis is the appropriate methodology to use for this Lexis model, correct?
There is no literature about this appropriate Lexis model, correct?
This, January 30th, 2025, you prepare your initial report, correct?
Correct.
In that initial report, you mentioned nothing about text stream event 1162.1, correct?
Correct.
In that report, you mentioned nothing about text stream event 1162.2, correct?
Correct.
The trial starts April 22nd, correct?
Correct.
Roughly.
Generally.
No, the trial in this case, this trial, about April 22nd, after the trial starts and after witnesses, of course, are appearing, you prepare another report, correct?
Correct.
And that's your May 8th report,
Correct.
right in the middle of this trial.
Correct.
And right in the middle of this trial, you enlarge the number for the 21 to 29 range. That's bigger than what was in your first report, correct?
No, that is not correct.
Well, you changed the number, don't you?
No, I did not change the number.
Well, let's go back to see exactly what you did, sir.
Sure.
Let's start with the basics. You said on direct examination, sir, that you prepared your May 8th report on your own. Those were your words on your direct testimony, correct?
Correct.
I'm going to read the first line of your May 8th, 2025 report.
Okay.
Do you have it in front of you, sir?
I do, yes.
It starts, Dear Mr. Brennan. Do you see that?
Yes, I do.
Pursuant to your request. That's a request you're referring to of Mr. Brennan, correct?
Correct.
I have completed an additional analysis concerning the above referenced matter. To formulate opinions, the following additional items were reviewed. This wasn't done on your initiative. You put in writing you did it at the request of Mr. Brennan. Which is it?
So that was on my own initiative. This is a holdover, so a copy and paste.
Not all of the state's witnesses, however, were bad witnesses for the defense. In fact, Maureen Hartnett, who was the crime scene analyst, the DNA person, and the person who essentially did the review from a forensic point of view on the SUV, her testimony was, I thought, extremely relevant. And one of the best pieces that came out of it was about what was not found.
Did you notice anything of note in the undercarriage, as you just described it, of the vehicle?
No, I did not.
And as regards sampling that you discussed on your direct examination, did you take any samples of that undercarriage area of the vehicle?
I did not collect anything from the undercarriage, no.
And is the reason you didn't collect anything because you didn't see anything of note that was worthy of collection?
In addition to that, I also performed some testing of that area.
And what testing of that area did you perform?
I performed screening tests on some of the lower lying areas of the undercarriage, on the tire flaps, the edge of the bumper, the muffler pipe.
And what were the results of that testing, that screening testing?
Those results were negative.
One of the angriest and probably the least focused witness that they had for the Commonwealth in this case was Yuri Buchananic. And that was because he didn't want to be there. If he wanted to be there at all, he wanted to be there and testify just about the things that he did. But instead, the Commonwealth put him in the unenviable position of taking the jury through Mr. Proctor's work. And that opened him up to cross-examination about Mr. Proctor's work, which he otherwise might have been able to avoid, claiming it wasn't relevant. But since the Commonwealth put him in that position, he had to get in there and answer questions. One of the things that you expect from a police officer are succinct yes or no questions. And if they saw something different than you think they should have seen, they're just going to tell you, that's what I saw, and that's the end of it. And usually that kind of thing works with a police officer, but it doesn't work here because Yuri Buchananic is angry. He's angry at the people who put him in this spot. He's angry at Proctor. And he knows in order to keep putting bricks in that blue wall, he has to get up there and take the stand and say that Proctor did everything right when he knows very, very well that he didn't do everything right. And this segment of testimony here is going to be a thorn in his side if he ever has to testify again. When you have somebody who is looking for nude pictures in a cell phone and you send a thumbs up and you give the imprimatur of, that being okay, that creates a presumption in the mind of a jury that you don't understand what honor and integrity actually are. Watch.
That was sent by Trooper DeChico to the group.
According to this document, yes.
Who is depicted in that photograph?
The big story, Mr. David Yannetti, criminal defense attorney.
Do you see that person in court?
Yes, I do.
Where is he seated and what is he wearing?
He's seated right there wearing a blue tie and a dark suit, white shirt.
Thank you. We can bring the lights up, Your Honor. Okay. In response to, and going back to the multi-page document FF, in response to Trooper DeChico's photograph that he sent to the group, you responded to that photograph, did you not?
Yes, this document indicates so, yes.
And you responded by laughing at it, correct?
That's what it says, yes.
Well, that's what it says, or that's what you did?
I don't remember.
Trooper Proctor then, former Trooper Proctor, Michael Proctor, then responded, correct?
That's what it says here, yes.
And he responded to the group, funny, I'm going through his retarded client's phone, correct?
That's what it says, yes.
Michael Proctor then responded again. Is that right?
Yes.
He wrote, no nudes so far, correct?
That's what it says, yes.
Michael Proctor responded yet again. Is that right?
That's correct.
And in reference to Mr. Yannetti's photograph, he wrote, I hate that man. I truly hate him. Correct?
That's what it says.
There's a trooper by the name of Moore, M-O-O-R-E, correct?
There is.
And he disliked Trooper Proctor's phrase, his statement, no nudes so far, correct?
That's what it says.
Did that indicate to you that Moore was disappointed that Trooper Proctor, Michael Proctor, had not found naked pictures of Miss Reed as yet?
I don't know what that indicated for Mr. Moore.
And then you responded to the phrase, funny, I'm going through his retarded client's phone, correct?
I acknowledged that text message being sent.
You acknowledged it by liking it, correct? With a thumbs up.
I acknowledged it by responding with a thumbs up emoji.
The fact is, Trooper Proctor told you, his supervisor, in this series of text messages, that he was going through Miss Reed's phone. Is that right?
Correct.
And he also informed you, his supervisor, that he was going through her phone looking for nudes or naked pictures of her on her phone, correct?
He did not tell me that he was going through naked pictures, for naked pictures through the phone.
He wrote, no nudes so far, right?
That is what is written, yes.
What did you think he was looking for when he wrote that phrase?
I don't know what he was looking for.
What would be a reasonable interpretation of what Michael Proctor was looking for when he wrote, no nudes so far?
I don't know.
Motorcycles, handbags, pair of shoes, or naked pictures of Miss Karen Reed?
His mission was to go through the phone to look for digital evidence that's related to the crime. The fact that he wrote no nude so far, I cannot comment on.
You cannot comment on, or you don't want to comment on?
I don't know what he was looking for in that specific time.
You certainly did nothing. You took no action to stop him from potentially looking for naked pictures of my client, correct?
That's correct.
In fact, last week you testified that in your view, Michael Proctor handled himself in this investigation with integrity. That's what you said, correct?
That's correct.
Do you stand by that testimony?
The investigation was handled with integrity and honor.
And not only does he not understand integrity and honor, he couldn't even bring himself to admit, after seeing it on video, that Karen Reed hit the car, John O'Keefe's car. And this explanation is the kind of thing that makes jurors go, what? What did he just say? Did he say that he saw this, but he doesn't believe, he can't really say whether or not he saw it? Because clearly, if you see that, you know that he hit the car. It wasn't just close to it. And this is one of those things where if you're a witness, you lose a lot of credibility when you dance around the truth. And it's pretty clear he's dancing around the truth here.
Pause it. Let's go ahead and zoom in on the upper left-hand corner. Okay, go ahead and play. Pause. Did you see anything happen with the left rear tire of the other car in the driveway?
Which car are you talking about?
The highlighted portion, the parked car, which is the left rear tire that's zoomed in on.
I wasn't paying attention to the tire. Can you play it again, please?
With the court's permission?
Okay.
Let's try that one more time. Pause it. Okay, you can take that down. Did you see anything happen with that left rear tire of the Chevy Traverse?
Based on that video, it appears there might have been movement there.
Last year, and you've seen this video several times, correct?
I have.
You saw it during the course of your investigation, not just in the course of proceedings, correct?
Right.
Last year, you indicated that you observed the vehicle, Miss Reed's vehicle, come near Mr. O'Keefe's car. Which one in that video was Mr. O'Keefe's car?
The Chevy Traverse.
And that would be the car that was parked and static, not moving, correct?
Correct.
Having seen this, do you still believe that the SUV came near the Chevy Traverse, or do you believe it struck the Chevy Traverse?
With the clarity of that video, there is a lot of movement in the shot. Not with great certainty. It appeared that there was movement of the tire, but I cannot say with 100% certainty that there was movement.
It wasn't just the professional law enforcement officers who made fools of themselves during testimony. There were several lay witnesses who absolutely could not be believed because clearly you can tell when someone is jumping around that they're very nervous and you know you're getting close to the truth, which they will immediately deny. There's no better example of that than this segment where Jennifer McCabe denies that she called her friend so that they could get their story straight. Anybody looking at this from a distance knows they weren't just chatting about whether or not to expect another call. They were talking about what are we going to say to make this all work out. And that's my opinion. I mean, I guess I don't know that for a fact, but that's what I interpret from this exchange. Watch.
Did reviewing those paragraphs refresh your recollection as to whether or not, as to what you told those agents initially? I'm sorry, what you told those officers initially from that other law enforcement agency, that about who you contacted in that 10-minute interval?
Yes, I told them.
And you told them that you had contacted your husband, Matt McCabe,
Yes,
and Carrie Roberts.
correct.
I want to stick with that for just a quick second. One of the first calls you made after being contacted by these other law enforcement officers from a different agency, one of the first calls you made was to Carrie Roberts. Is that right?
If she was the first one,
That's what I'm asking. One of the first two calls you made, your husband,
right.
come home, there's law enforcement outside my door, I'm guessing is what you said, correct?
I don't remember my exact words now, but I did ask him to come home, correct?
And
Yes.
Carrie Roberts.
Okay, yes,
You wanted to let Miss Roberts know that you had been contacted by certain officers from a different agency, correct?
I was curious if they had already been to her.
That was
Because-
that was my next
Oh,
question.
yeah.
You also wanted to find out had these law enforcement officers from this different agency contacted her, correct?
Yes, because typically, if
I
you
just
enter
asked
our
yes or no.
town, she's.
Ms. McCabe, yes or no?
Oh, sorry, I was just trying to
That's
explain.
okay.
I'm sorry.
Is that why you contacted her, to find out if in fact they had contacted her before you? Yes or no?
Yes,
You wanted to find out if she had talked to these particular law enforcement officers and what she had told them so that your story could somehow align, or it could inform how you responded to questions that they asked you. Isn't that true?
that's not true. We both.
When the Commonwealth's witnesses were finished, it was time for the defense case to come in, and Dr. Wolf was indeed a superstar in terms of presenting the forensic evidence. This is a guy I would want in any high-profile case if it involved a vehicular accident, because it's pretty clear not only that he knows his stuff, but he knows how to testify too. Pay particularly close attention to his use of to the use of language in explaining what he's seeing here and why he believes what he believes.
You'll see is actually an artifact of the test, if you will, where the taillight, due to the fact that the impactor stops at the end of the stroke, that force actually causes it to decouple from that polyurethane foam that we use to adhere the two.
What do you mean by decouple? What does that mean?
So, as I mentioned, it once the linear impactor reaches the end of its stroke, it stops instantaneously, and the force of that stop just caused where we adhered the two together, just caused it to detach, basically break away. So in essence, it doesn't matter because we only care about that. Remember, we're talking about that short duration of time, that 10 milliseconds. So once it breaks, it's already reached a common velocity to the taillight.
Okay. Can we go ahead and go to the next slide, please? What do you note about this impact?
So one of the things you'll see is kind of that dust cloud that you see. Again, that's all the particulates from the expanding foam that we use. So that's kind of what you see in the background there, kind of going over kind of the arm and the taillight there.
Do you note more damage or less damage to the taillight at 17 miles an hour versus the 10 mile an hour test?
There is more damage, yes.
Let's go to the next slide, please. What are we looking at here?
So you're looking at a top-down view from the high-speed camera. You'll see the taillight enter from the left, impacting the arm at about 17 miles per hour.
Okay, go ahead and play it. Can you describe the decoupling that's shown here?
Absolutely. So as you can see where the two are basically married together, right? It's kind of actually coming back together now. So that bond that we had, right, this is the most effective way that we could mount it to the impactor. It just became detached due to the force of that impactor stopping at the end of the stroke.
Understood. Next slide, please. What are we looking at here?
So in this slide, you're looking at another high-speed video. This is just a side view. Again, you're going to see the taillight enter the frame from the left, impacting the arm at 17 miles per hour.
Is this in slow motion as well?
This is in slow motion, correct, not real time.
Okay. What do you note in terms of the deflection on the arm?
The arm, as we saw in the previous one, is accelerated up, so it's moving now at roughly a common velocity with what the impact speed was.
And what did you note about the damage to the taillight?
It was more significant than the 10-mile-an-hour test, which, again, there was very minimal damage to that, where several fragments of that red outer lens fractured as well as the clear lens.
Okay, next slide. What is this a picture of, or pictures of?
This is a side-by-side comparison showing a depiction of the 17-mile-an-hour test impact to the test taillight, comparing it to that of the subject taillight.
Were you able to reach any conclusions or opinions as to whether or not the damage to the subject taillight on the right is consistent with striking an arm at 17 miles per hour?
It's inconsistent from a damage perspective.
What's the basis of that opinion?
The test that I've just showed you all.
Was that testing that we've just talked about conducted in accordance with the scientific literature and generally accepted methodologies that you've earlier described?
Yes.
Is the damage to the right rear taillight consistent with striking John O'Keefe's arm at 17 miles per hour?
No.
Do you hold that opinion to a reasonable degree of scientific certainty?
Yes.
Slide 45, please.
I am sometimes amazed at the stupid things that lawyers do in trial. A lot of times they forget things. A lot of times they lose their train of thought when they're doing a questioning of a witness and that sort of thing. I mean, that's not really stupid. That's just the kind of stress that builds up in the course of a trial. But one thing that you almost never do is you ask questions about something you don't know anything about. So, to me, when Mr. Brennan asked questions about the holes on the back of the hoodie, he either knew those holes had been created by the crime scene technician, or he didn't know, and if he didn't know, he clearly should have known, because you never ask questions you don't know the answers to in trial. That's what depositions are for, that's what discovery is for, that's why you have a list of all your exhibits, you have paragraphs on the side of each piece of paper that goes over these things, explaining what they are. All of that stuff is very, very important, and you know the other side has the same stuff, that they have looked at the same exhibits you have, that they've looked at the same documents you have, and that they have a whole team that's going over this stuff with a microscope. And you don't do anything stupid or try to be cagey about it. So if you don't know, you leave it alone, and if you do know and you do something like this, you should be disbarred because it's an attempt to mislead the jury. I have to say, I don't know if it was an attempt to mislead the jury or not. It looks that way to me. That's my opinion. But ultimately, it will be up to somebody else to decide if that's what happened here. And certainly the jury gets a vote in that too. But if your case is strong, you don't need to cheat. And this certainly looked like cheating. When he held up those holes and asked Dr. Wolf about it, he made an idiot out of himself, and this is the result.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. And the parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury they are to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
Then we got treated to the testimony of Officer Baros. And Officer Baros, or I should say Sergeant Baros, one of the prosecution's witnesses in the first trial, for some reason, they didn't put him back on the witness list at this trial. Wonder why that could be. At any rate, this was his testimony that, in many respects, was pretty damaging to the Commonwealth's case.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you call it?
The piece was about maybe this big.
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere in there.
Then Mr. Jackson got him to explain how the taillight that he saw in the Reed's driveway, how it was different from the taillight that was photographed in the Sally Port.
Sergeant Baros, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
What's different about this photo, sir?
That taillight is completely smashed out.
And now we come to my favorite witness in this entire trial. While I liked Dr. La Posada, and while I liked Dr. Russell and all of the other expert witnesses brought to us by the defense in this case, the one defense witness that absolutely stole the show was an honorable guy doing an honorable job, trying to keep his family fed, multiple jobs. He clearly came off as somebody who is dedicated to what he does. And I think he won the hearts and minds of most people with this very short segment of testimony. You know, of course, before this, he testified that he didn't see anything in the 3 times that he went by that residence at 34 Fairview. But what really won the day, like I said, was this little segment of testimony, which you'll hear next.
My attention's focused out the front window, to the right and to the left.
Why?
I am looking for pedestrians. I'm looking for residents that may be backing out, not aware that I'm there, and God forbid, animals.
Some people are just made for certain moments in time. You know, Abraham Lincoln was the president at the most important part of our early founding in this country. He was there and shepherded the country through the Civil War. And as a reward for that, he was shot by somebody who was upset by the fact that he had gotten this through the Civil War, which was really odd considering what a forgiving attitude he had toward the Confederate or the Southern states. The people who followed him didn't have such a forgiving attitude. What I find interesting is that many times when, you know, a hero is needed, a hero appears. And I don't believe that's random. I believe that the good Lord has a hand in that. And as it pertains to Karen Reed, the hero here is Jackson's team. And certainly with Jackson at the helm. Jackson and Alessi and Yannetti, those guys did really important work in this trial. And it all led up to the penultimate moment where they closed the case. And I'm going to run through several segments of the closing here because I think they are so important. And then I've got one more thing to say after that, and we'll finish this up.
And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12/31/38. Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12/31/38, which is the time Welcher clocked for the moment of the impact. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shannon Burgess. Question. Can you believe him? Can you believe Mr. Burgess? He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question. This is how John O'Keefe died. A rearward fall from a standing position. What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed us? Standing up, falling straight back. Add a laceration to the right eye consistent with a fist or a punch, and you've got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. La Posada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out. What a shame. Remember the question that was posed by Mr. Brennan, did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rentschler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Scorti-Bello, not Dr. Isaac Wolf. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, They didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher. It was really cold and windy, and I didn't know if there was a crime that had been committed. What? You didn't know that a crime had potentially been committed? You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen, in a house, 30 feet away. And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating. The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it. Of course this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit? Nope. He's a Boston cop too. End quote. That quote starts to make a little more sense now, doesn't it? The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from it. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses and for bias. Not just any bias. Bias in this case. Fired. This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single witness is who had access to that shirt and who had access to those taillight fragments, and the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You've got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those Solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the Solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason?
Then we have this, which is what I think is a really important, probably the most important piece of evidence, because it demonstrates beyond a doubt that Karen is not guilty.
In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your Lyin Eyes. The taillight's completely lit up. That would be impossible.
If the taillight is intact at 5 o'clock in the morning when she leaves the garage, it means she didn't hit him with the car at 12:30, 5 hours previously, or 4.5 hours previously. I don't know why they didn't put this photograph up every time they had an expert on the stand, every time they had one of the prosecution's witnesses on the stand. I don't know why they didn't put it up and say, what about this? But sometimes you hold the best for last, and I think that's what they did here. And I thought that was a really important moment in the trial. What did you think was the most important moment in the trial? What were you thinking when you saw that? What other favorite moments do you have in the trial? Drop me a comment, and I'm pretty sure we're going to do a comment video at the end of this trial. And also, we may do a live stream on the day that the verdict comes in, probably that evening, maybe around 7.
That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.